Hello and welcome to today's session on legal framework of corporate governance in India. I'm Dr. Maruf Ahmed Mir, PhD in financial markets and MBA in finance and accounts from AMU Aligarh. And at present, I am associated with Asian Business School, Noida as associate professor in finance and accounts. Dear students, let's start with understanding the legal framework of corporate governance in India. Corporate governance is the framework for managing and directing businesses. The governance of corporations is the responsibility of the board of directors. Therefore, it has to be separated from the day-to-day operation and administration of the firm by full-time executives. It is about what the board of company does and how it determines the value of the organization. There are 8 significant features of good corporate governance, which include accountability, transparency, effective principles and policies, responsiveness, participatory decision-making process, efficiency, consensus-oriented operations, equitable administration, and in accordance with the rule of law. The adoption of such aspects wherein the creation of appropriate incentives shall aid management and the board of a business in attaining the objectives that shall help yield the best interest of the firm and its shareholders should represent the characteristics of excellent corporate governance. Good governance in the simplest form refers to the procedures that an organization must follow in order to be directed, regulated, and controlled. It is a way to ensure that a company's management, board, and the directors act in the best interest of the business and its stakeholders, as well as to hold the managers responsible to the capital providers for how the business uses its assets. The organizational framework for corporate governance initiatives in India consists of Ministry of Corporate Affairs (MCA) and the Securities and Exchange Board of India (SEBI). SEBI monitors and regulates corporate governance of listed companies in India through Clause 49. This clause is incorporated in the listing agreement of stock exchanges with companies, and it is compulsory for listed companies to comply with the provisions. MCA, through its various appointed committees and forums such as the National Foundation of Corporate Governance (NFCG) and non-for-profit trust, facilitates exchange of experiences and ideas amongst corporate leaders, policy makers, regulators, law enforcing agencies, and non-government organizations. Regulations. The Companies Act 2013 got assent of the President of India on 29th August 2013, and it was enacted on 12th September 2013, repealing the old Companies Act 1956. The Companies Act 2013 provides a formal structure for corporate governance by enhancing disclosures, reporting, and transparency through enhanced as well as new compliance norms. Apart from this, the Monopolies and the Restricted Trade Practices Act 1969, which is replaced by the Companies Act 2002, the Foreign Exchange Regulatory Act 1973, which has now been replaced by Foreign Exchange Management Act 1999, the Industries Development and Regulation Act 1951, and other legislations also have a bearing on the corporate governance principles. In addition to various acts and guidelines by various regulators, non-regulatory bodies have also published codes and guidelines on corporate governance from time to time. For example, Desirable Corporate Governance Code by the Confederation of Indian Industries (CII) in 2009. The issue of corporate governance for listed companies came into prominence with the report of Kumar Mangalam Birla Committee 2000, set up by SEBI to suggest inclusion of a new clause, Clause 49, in the listing agreement to promote good corporate governance. On 21st August 2002, the Ministry of Finance appointed the Naresh Chandra Committee to examine various corporate governance issues, primarily around auditor, company relationships, rotation of auditors, and defining independent directors. This was followed by the constitution of the Narayana Murthy Committee 2003 by SEBI, which provided recommendations on issues such as audit committees' responsibilities, audit reports, independent directors, related parties, risk management, independent directors, director compensation, code of conduct, and financial disclosures. Many of these recommendations were then incorporated in the revised Clause 49 that is seen as an important statutory requirement. Further, after enactment of the Companies Act 2013, SEBI has amended Clause 49 in 2013 to bring it in line with the new Act. Board of Directors. The Desirable Corporate Governance Code by CII 1998 for the first time introduced the concept of independent directors for the listed companies and compensation paid to them. The Kumar Mangalam Birla Committee 2000 then suggested that for a company with an executive chairman, at least half of the board should be independent directors, else at least one-third. The updated Clause 49 based on the report by the Narayana Murthy Committee further elaborates the definition of independent directors and also requires listed companies to have an optimum combination of executive and non-executive directors, with non-executive directors comprising of at least 50% of the board. The 2013 Act introduces the requirement of appointing a resident director and a woman director. The term key managerial personnel has been defined in the 2013 Act, comprising of Chief Executive Officer, Managing Director, Manager, Company Secretary, Whole-time Director, Chief Financial Officer, and any such other officer as may be prescribed. In 2013 Act has also introduced new concepts such as performance evaluation of the board, committee and individual directors. The revised Clause 49 in 2013 now also states that all compensation paid to non-executive directors, including independent directors, shall be fixed by the board and shall require prior approval of shareholders in the general meeting, and that limit shall be placed on stock options granted to the non-executive directors. Such remuneration and stock option is required to be disclosed in the annual report of the company. The independent directors are also required to adhere to a code of conduct and affirm compliance to the same annually. Audit Committee. The Audit Committee's role flows directly from the board's oversight function and the delegation to various committees. It acts as an oversight body for transparent, effective, anti-fraud and risk management mechanisms, and efficient internal audit and external audit functions, financially reporting. As per Section 177 of the Companies Act 2013, read with Rule 6 of the Companies, Meetings of the Board and its Powers, Rules 2014, every listed company and all other public companies with paid up capital of rupees 10 lakh crore or more, or having turnover of 100 crore or more, or having in aggregate outstanding loan or borrowings or debentures or deposits exceeding rupees 50 crores or more, to have an audit committee which shall consist of not less than 3 directors and such number of other directors as the board may determine, of which 2/3 of the total number of members shall be directors other than managing or whole-time directors. The Kumar Mangalam Birla Committee, Naresh Chandra Committee and Narayana Murthy Committee recommended constitution composition for audit committee to include independent directors and also formulated the responsibilities, powers and functions of the audit committee. The audit committee and its chairman are also entrusted with the ethics and compliance mechanism of an organization, including review of functioning of whistleblower mechanism. The revised clause 49 expands the role of the audit committee with enhancing its responsibility in providing transparency and accuracy of financial reporting and disclosures, robustness of the system of the internal audit and internal controls, oversight of the company's risk management policies and programs, effectiveness of the anti-fraud and vigil mechanism, and review and administration of related party transactions of the organization. Subsidiary companies. The rationale behind having separate provisions with respect to subsidiary companies in the revised clause 49 was the need for the board of holding company to have some independent link with the board of the subsidiary and provide necessary oversight. Hence, the recommendation of Narayana Murthy Committee to make provisions related to the composition of the board of directors of the holding company to be made applicable to the composition of the board of directors of subsidiary companies and to have at least one independent director on the board of the directors of the holding company on the board of directors of the subsidiary company were incorporated in the revised clause 49 of the listing agreement. Besides, the audit committee of the holding company is to review the financial statements, in particular investments made by the subsidiaries, and disclosure about the materiality significant transactions ensures that potential conflict of interest with those of the company may be taken care of. The definition of subsidiaries also widened by the Companies Act 2013 to include joint venture companies and associate companies. Role of institutional investors. Fast growing countries like India have attracted large shareholding by international investors and large Indian financial institutions with global ambition. This has resulted in a significant progress in the standards of corporate governance in the investee companies. Many research reports published in recent years show that companies with good governance system have generated high risk adjusted return for their shareholders. So if a company wants institutional investor participation, it will have to convincingly raise the quality of corporate governance practices. Indian companies thus need to adopt the best practices such as OECD corporate governance principles revised in 2004 that serve as a global benchmark. In countries like India, where corporate ownership still continues to be highly concentrated, it is important that all shareholders, including domestic and foreign institutional investors, are treated equitably. Institutional investors are expected to actively participate in the AGM voting in the shares held by them in their portfolio companies, along with the public disclosure of their voting records and reasons for non-disclosures. Their reason for assenting or dissenting to any board resolution of the portfolio companies shall be disclosed on their website. Stakeholders Relationship Committee. As one of its mandatory recommendations, the Kumar Mangalam Birla Committee propounded the need to form a board committee under the chairmanship of a non-executive director to specifically look into the redressing of shareholder complaints like transfer of shares, non-receipt of balance sheet, non-receipt of declared dividend, etc. The committee believed that the formation of shareholders grievance committee would help focus the attention of the company on shareholders grievances and sensitize the management to redress their grievances. In 2013 Act, as well as the revised clause 49 now mandate the formation of such a committee with broader remit to cover issues and concerns of all the stakeholders and not just shareholders. In the 2013 Act now mandates companies with more than 1,000 shareholders, debenture holders, deposit holders, and any other security holders at any time during a financial year are required to constitute a stakeholders relationship committee consisting of chairperson, who shall be a non-executive director, and such other members as may be decided by the board to resolve the grievances of security holders of the company. Risk management. The Kumar Mangalam Birla Committee report included mandatory management discussion and analysis segment of annual report that includes discussion of industry structure and development, opportunities, threats, outlook, risk, etc., as well as financial and operational performance and managerial development in human resource, industrial relation front. Clause 49 includes this recommendation as a part of management disclosures. Risk management was, however, propounded for the first time by the Narayan Murthy Committee 2003 in its report, by which it required that the company shall lay down procedures to inform board members about the risk assessment and minimization procedures. These procedures shall be periodically reviewed to ensure that executive management controls risk through means of a properly defined framework and overlooked by a risk management committee. This is incorporated in clause 49 as a part of internal disclosure to the board. The 2013 Act and revised clause 49 specify requirements related to risk management. Audit committee and the independent directors of the company are entrusted with the responsibility of evaluating the robustness of the risk management systems and policy laid down by the board. Ethics. A code of conduct creates a set of rules that become a standard for all those who participate in the group and exists for the express purpose of demonstrating professional behavior by the members of the organization. The Naresh Chandra Committee for the first time recommended that companies should have an internal code of conduct. The report by Narayan Murthy Committee further recommended that a company should have a mechanism, whistleblower, to report on any unethical or improper practice or violation of code of conduct observed, and that audit committee would be entrusted with the role of reviewing functions of the mechanism. Clause 49 incorporated these recommendations, further mandates directors of every listed company to lay down a code of conduct and post the code on their company's website. The board members and all senior management personnel are required to affirm compliance with the code annually and include a declaration to this effect by the CEO in the annual report. The recommendation of Narayan Murthy Committee to make audit committee responsible for reviewing the functioning of the whistleblower mechanism where it exists is incorporated in the clause 49. The 2013 Act and revised clause 49 mandate establishing whistleblower mechanism to let employees and directors blow whistles on financial and non-financial wrongdoings, and also that such mechanism should provide protection to the whistleblower from victimization and provide direct access to the chairman of the audit committee in exceptional cases. Executive remuneration. The overriding principle in respect of directors' remuneration is that of openness, and shareholders are entitled to a full and clear statement of benefits available to the directors. The 2013 Act and revised clause 49 mandate the formation of a nomination and remuneration committee comprising of at least 3 directors, all of whom shall be non-executive directors, and at least half shall be independent. The nomination and remuneration committee is to ensure that the level and the composition of remuneration is reasonable and sufficient. The relationship of remuneration to performance is clear and meets appropriate performance benchmarks. And the remuneration to directors key managerial personnel, and senior management involves a balance between fixed and incentive pay reflecting short and long-term performance objectives appropriate to the working of the company and its goals. There are also compulsory disclosures to be made in the section on corporate governance of the annual report. All elements of remuneration package of all the directors, that is salary, benefits, bonuses, stock options, pension, etc., detailed of fixed components and performance linked incentives along with the performance criteria, service contracts, notice period, severance fee, stock option details if any, and whether issued at a discount as well as the period over which accrued or over which exercisable. Directors' responsibility statement. To promote better disclosure and transparency, the 2013 Act requires the company's annual report to include a director's responsibility statement stating the following. A. Applicable accounting standard had been followed in the preparation of the annual accounts. Part B. The directors have selected such accounting policies and applied them consistently and made judgment and estimates that are reasonable and prudent so as to give a true and fair view of the state of affairs of the company. C. Proper and sufficient care for the maintenance of adequate accounting records in accordance with the provisions of this Act for safeguarding the assets of the company and for preventing and detecting fraud and other irregularities. Part D. The annual accounts of the company are prepared on a going concern basis. E. The directors have laid down internal financial control to be followed by the company and that such internal financial control are adequate and were operating effectively. F. The directors had devised proper systems to ensure compliance and the provisions of all applicable laws and that such systems were adequate and operating effectively. CEO, CFO certification. Internal control is a process effected by an entity's board of directors, management and other personnel, designed to provide reasonable assurance regarding the achievement of objectives in the following categories: effectiveness and efficiency of operations, reliability of financial reporting, and compliance with applicable laws and regulations. The Naresh Chandra Committee for the first time required the signing officers to declare that they are responsible for establishing and maintaining internal control which have been designed to ensure that all material information is periodically made known to them and have evaluated the effectiveness of internal control systems of the company. Also, that they have disclosed to the auditors as well as audit committee deficiency in the design or operations of internal control if any, and what they have done or proposed to do to rectify these deficiencies. Clause 49 requires the CEO and CFO to certify to the board the annual financial statements in the prescribed format and establishing internal control systems and procedures in the company. CEO and CFOs are thus accountable for putting in place robust risk management and internal control system for their organization's business processes. 2013 Act and revised clause 49 have also brought much rigor into internal control certification by making it as one of the parts of director's responsibility statement. That is all for today. Hope you have understood. So we will meet in the next episode with a new topic. Till then, take care. Goodbye.